everybody. I'll call this recommending committee meeting of November 14th to order. Are we in compliance with the open meeting law?
Yes, we are.
This meeting has been posted in various locations throughout the city. We'll move to the first item. Bill number 200659 establishes certain minimum community service requirements as part of the punishment for contributory delinquency or contributory neglect related to graffiti or property damage, sponsored by Mayor Oscar B. Goodman. Staff?
I'll make this presentation. This is an ordinance that the mayor had requested to help with the enforcement of the graffiti prohibitions. As you know, our court doesn't have jurisdiction over juveniles, but it does have jurisdiction over parents of juveniles and guardians. And our criminal division has used in the past our contributory negligence or contributory neglect statute and ordinance to prosecute parents and guardians, and this bill would establish a minimum set of penalties, community service, restitution, etc. for a parent or guardian who's convicted of contributory delinquency or contributory neglect when it's related to graffiti or property damage. It provides as an alternative to serving that those additional penalties that the parent or guardian can meet those requirements by participating with and being present with the minor who has been engaged in the activity, and that would satisfy their obligations to the court.
Are there any questions from the audience?
I have a question. I'm wondering, I just want to make sure that section B2, we were a little...
You need to come to the microphone and state your name. That's all right.
Obviously, my first recommending committee meeting. I'm Lee Rowland, staff attorney for the ACLU of Nevada. We discussed this, and I think it just cleared it up, but I just want to make sure section, for instance, B2, this does not contemplate giving this punishment to someone who has not been tried themselves, right? So this is all dependent on an independent violation of the statute.
That's
okay.
correct.
Just wanted to make sure. Thanks. And also, this increases the penalties under state law. We did submit a memo. I think it's certainly not an area of expertise, but we just did bring it up that there seems to be case law that suggests that municipalities lack the authority to significantly increase penalties under state statutes. So we simply recommended that it be submitted for thorough legal review to make sure that it's constitutional. We're concerned that it raises a equal protection argument that certain people will be tried differently under state statute depending on where they are in the state. So I think that's a legal issue that bears some investigation. I don't know if the city attorney's office has already covered that topic.
Just in response to that, this would be a prosecution under state law, and the maximum penalties that can be imposed by a city are 6 months or $1,000. This would never exceed that because we can't. So I think it would be completely consistent with state
So
law.
it's within the prior authorization.
Yes,
Okay, thank you again.
Thank you. Are there any more comments? Hearing none, then, do I hear a recommendation?
Councilwoman, I would make a motion to refer to council with a due pass of agenda item 3.
All in favor?
Aye.
Opposed? Just thought I'd put that in. Okay, the motion passes. We'll move to the second item, which is Bill number 2006-60. It updates sign standards and related approval processes for the downtown casino and downtown entertainment overlay districts, sponsored by Mayor Goodman. Staff.
Councilwoman and Councilman Margot Wheeler, Planning and Development. This ordinance makes some changes to the sign standards in that unique district, specifically to allow freestanding signs which previously were not allowed. Staff is recommending approval.
Any comments from the audience? No comments? Do you want to make a motion?
Councilwoman, I would make a motion to, on agenda item number 4, to refer to council with a due pass.
All in favor?
Aye.
The motion passes. Item number 3 requires the applicant for a general plan amendment to conduct a neighborhood meeting sponsored by Councilman Gary Reese.
That's number 5.
Oh, have I?
You just said.
Oh, I meant the third item. I didn't mean the.
That's okay.
I'm talking about the. Okay. Bill number 206, I've already stated, requires the applicant for general plan amendment to conduct a neighborhood meeting sponsored by Councilman Gary Reese.
Council members, this item comes forward to put into the code the current practice with regard to general plan meetings. It sets the time standards and what is necessary within the notices. Originally, we had it written that there be a affidavit filed by the applicant. In discussions with several of the council members, there was concerns that the city be the one to send out the notice and to the mailing list to ensure the accuracy of the information and the utilization of the list and the timeliness. Mr. Steed has some language that could be added to make that change to the ordinance.
Yes, that would be, there's a new section 8 in the ordinance which ends on the top of page 2, and we would propose adding 2 additional sentences that would say the department is authorized to establish a procedure by which the applicant may elect to have the department provide the notice required by this paragraph. The department shall develop and use an appropriate form by which the election may be made and is authorized to charge a notification fee to provide the required notification. We'd recommend that as a first amendment.
So then the applicant would be the one who would be paying for the mailing?
Yes.
And that language is so that we're in compliance with state law.
State law imposes that notification burden on the applicant, and we can't really change that, but if we convince an applicant that it's better for everybody if we do it, then we will have them sign a waiver under state law and then do the notification for them, charge them the fee. Hopefully everyone's happy.
All right, any comments from the audience? Hearing none, are we ready?
I have a comment before we
Okay.
move on this. This will, I think, hopefully streamline the process, Councilwoman, in regards to applicants not fulfilling their obligation in regards to notifying all the neighborhood. There are oftentimes, as we give them the lists, and out the door they go, they currently sign an affidavit that says, hey, I'm going to send these out. And oftentimes, I know my constituents, well, I never get notification of neighborhood meetings. I think this will eliminate that problem, but I appreciate the state law portion of it, because I was unaware of that.
In discussing with Mr. Steed,
awesome.
he came up with the correct
That
language.
was perfect. So I just want to make that comment. This helps all of our constituents in every ward, and I think Councilman Reese is aware of this as well as the addition of the amendment to this.
I think it is very important. It gives us the consistency we need too, because sometimes with pressuring, we would get it out and sometimes we would not.
Yeah.
And so this gives us consistency. That's very important. Brings more community involvement. Ready for the motion?
With that, Councilwoman, I would move to refer to council with a due pass on agenda item number 5.
With the
As amended.
Okay.
As amended. All in favor?
Aye.
Aye. Moving on to item number 6, Bill number 2006-62, updates Title 11 of the Municipal Code relating to the regulation of traffic and parking, sponsored by none other than the famous Councilman Stephen D. Ross. Staff.
Good afternoon. Doug Towner with Detention and Enforcement. Detention and Enforcement conducted a review of Title 11, and this draft would have general language cleanup, incorporate our new technology, and bring parking ordinances in line with the current management needs.
Any comments from the audience before a comment by by Councilman Ross? Anybody in the audience? Okay.
I was getting so many traffic tickets that we had to... I am kidding, for the record, that is not true.
It's on the record.
I know, it's on the record. I just need to clean them up a little bit, so that's not what this is about. But again, as he described it, it is the cleanup, and we're always, especially detention enforcement, moving in the progressive direction, thinking outside the box, and doing a better job for the city. And I wish to extend my appreciation to them. And with that, we've moved to refer to council with a due pass, Councilwoman.
All in favor?
Aye.
Aye. The motion passes. Moving on to agenda item number 7. Bill number 2006-63 adopts a new chapter 10.44A of the Municipal Code relating to solicitation, proposed by Brad Jervik, City Attorney.
Councilwoman, members of the recommending committee, I'm glad to handle this one in the item that follows. As you're probably aware through briefings and certainly through newspaper articles, the Ninth Circuit Court of Appeals ruled a couple of weeks ago in the Fremont Street Experience case wherein the ACLU and others had raised challenges to Las Vegas Municipal Code 10.44, which relates to solicitation, and 11.68, which relates to regulations within the pedestrian wall. This first bill that you're considering now, 2006-63, addresses only solicitation. I know that others will have comments that they might like to make on it, but I'd like to make a bit of a record here. We have made a change to the definition of solicitation. I know the circuit had problems with it. We have changed it to remove some language and require that the kind of solicitation that we're talking about now be a solicitation for something immediately. That word immediate may sound like a small change, but it's a very significant change. Solicitation in the past encompassed a lot of activity, including solicitation for maybe business in the future. Come to my show next week and you get a discount. That could have been a solicitation. Other things of that nature. Right now, solicitation, and let me read this for the record, means the act of solicitation, including asking, begging, soliciting, or pleading for the purpose of immediately obtaining money, charity, business or patronage, or gifts or items of value for oneself or for another person or organization. The second major change to this particular ordinance is a removal of a prohibition against solicitation in the pedestrian mall. Turning your attention to page 2, 10.44A.030, used to have a subsection F, which prohibited solicitation in the pedestrian mall. That prohibition against solicitation under the new definition is now contained in the next bill that you're going to consider, but it is removed from the bill that you're considering at this point in time. Another thing that we have done, as you can see, this is 10.44A. It's a whole new chapter to the Las Vegas Municipal Code. We are not recommending at this point in time that we overwrite or modify 10.44. We still have some outstanding appellate issues, and we don't want to moot them out by erasing them or changing them or deleting that provision of the municipal code. If this item gets a due pass today from the recommending committee and is passed by the council tomorrow, becomes law, we will not enforce 10.44, but we will begin enforcement of 10.44A. With that, I'll be glad to answer any questions or let others make any comments they want to make.
Yes, from the audience. Please state your name first.
Yeah, good afternoon. My name is Jeff Victor. I'm the president and general manager of the Fremont Street Experience, LLC. I'm here today on behalf of the company and each of its 10 members, speaking in support of proposed ordinance 2006-64. As the council is aware, the Fremont Street Experience has been in operation since its creation in 1995. It was originally envisioned to be a truly unique, one-of-a-kind destination intended to attract millions of tourists every year and help to drive capital investment to the heart of downtown Las Vegas. Through the years between, the Fremont Street Experience has delivered on that intent. In fact, the LVCVA reported that the visitation to downtown in 2005 exceeded 17.7 million people. To put that visitation number in perspective, according to the trade publication Amusement Business, the two best attended amusement parks in the world in 2005 were Disneyland's Magic Kingdom in Orlando and Disneyland in Southern California. The publication reported that these two parks attracted 16.1 million and 14.5 million visitors, respectively, during the same year. Attracting attendance numbers like that doesn't happen by accident. To do so requires enormous capital investment, exceptionally inventive entertainment offerings, ongoing management, constant promotion, and the promise of delivering a clean, safe, and enjoyable environment. In 1995, the City of Las Vegas delegated the authority to manage the Fremont Street Experience to the company that I now preside over. Today and every day for the past 11 years, our office has successfully managed security, maintenance, cleanliness, promotion, advertising, live entertainment, light show programming, and special events that continue to define the Fremont Street Experience is one of the greatest tourist destinations available anywhere. The Ninth Circuit's recent decision regarding solicitation threatens to change all of that. It might not be widely understood that the company generates a significant portion of its revenues through the mall's leased retail operations, corporate sponsorships, sale of advertising space, and through hosting private events. The dollars generated by those activities are in turn spent to create free entertainment offerings, to pay for the electric bills, and to pay for the labor and supplies necessary to manage the cleanliness, security, and maintenance of the mall. These activities attract visitors who then spend the money to the various points of commerce, thus creating jobs and tax revenues. This rather simple formula works very, very well. But key to that formula is the company's ability to continue to manage the mall environment as it has done so for the last 11 years. Solicitation activities left unbridled are fundamentally incompatible with the character and function of the mall. Corporate sponsors will not be associated with an environment where panhandling is allowed to flourish. Advertisers will not pay to do so in an environment where others are allowed to do so for free. No event organizer will pay to have a private function in an environment where their clients will be exposed to intrusions from uncontrolled solicitations. No retail cart will want to pay for a lease in an environment where others are allowed to solicit their wares at will. Most significantly, the guest experience will be compromised. Make no mistake about it, the Fremont Street experience is not a place through which people travel to get from point A to point B. It is a destination where millions of tourists gather each and every year to be entertained, shop, and consume. In fact, our office works very hard to create experiences that encourage just that. When we douse the neon lights from the buildings and illuminate the biggest big screen on the planet, showing proprietary content only available at the Fremont Street experience, guests stop and engage in a 6 to 8 minute theatrical experience. When we host live concert events, guests stop and engage in the event for very long periods of time. They are a captive audience and as such are vulnerable to unwanted solicitors. Their only escape from the solicitation would be to exit the event. Similarly, guests will be highly vulnerable as they shop. Stopped, engaged in a transaction, wallets in hand, purses open, shoppers will be likely and easy targets for solicitation. Diners at the many outdoor eateries will also be targets. Captive in their seats, engaged in their consumption, solicitors will take advantage of the opportunity. Stop to get a soda from one of the mall's 28 vending machines, you're easy pickings for solicitors. In this light, visitors to the mall are just as vulnerable to solicitation as those getting money from ATMs, waiting at bus stops, walking through parking garages, or entering or exiting businesses, the same types of places where solicitation is already banned. We ask that the same ban be implemented at the Fremont Street experience so the mall can continue its mission to preserve and grow the downtown business corridor. I would also like to note that I have reviewed the records submitted to the City Council that supported the original ordinances, and I must add that the same market forces and pressures that were facing downtown more than 10 years ago are still facing us all. If anything, the competition has only increased since that time. The ordinance that's before you seeks to preserve the viability of the Fremont Street experience as a world-class commercial and entertainment attraction. Thank you.
Any other additional comments from the audience? Yes, sir. Please state your name first.
Yes, over here.
Richard Williams, 501 North Lamb, representing the Carpenters Union in Nevada. I have 3 copies of a letter here, if you'd like a couple of the copies. That's fine. Thank you. I have 2 other ones here. There we go. The Nevada Carpenters Union is requesting that the hearing on agenda items number 7 and 8 concerning the solicitation issue on the recommending committee agenda dated November 14th, 2006 be continued to a future date. The Carpenters Union does not feel that there is adequate time to review the proposed ordinance. We come to this determination based on the fact that an adoption vote is scheduled within 24 hours of today at the Las Vegas City Council meeting on November 15, 2006. The Carpenters Union feels that the impact of such an ordinance needs to be examined to determine if the rights of working people in Nevada are being infringed upon with regards to free speech and the right to demonstrate excuse me, within the Fremont Street experience. We feel that working people in Nevada have a right to express their views within the Fremont Street experience. For these reasons, we are asking the recommending committee to table these agenda items so that these concerns could be further addressed with adequate time before being voted on at the November 15th, 2006 Las Vegas City Council meeting. Thank you for your consideration.
I want you to know that after I received this letter, I did discuss it with Brad Jerbick to see if that could be done, because I could understand your concern about the lack of time.
Sure.
However, there is a problem that this will die if we don't move it on to the council. And Mr. Jerbick, could you explain that as a legal person, please?
I'll be happy, Councilwoman. What happened, the circuit ruled a little over 2 weeks ago and indicated in their decision that upon remand to the district court, they were to enjoin the city from enforcing the ordinances. That is the solicitation prohibition and the pedestrian wall regulations. Because we know it's coming, we feel that there's potential liability for the city today in enforcing any of those ordinances. And so upon receipt of the Ninth Circuit's opinion, we suspended enforcement of both the solicitation ordinance, which by the way applies citywide into activity well outside the pedestrian wall, and to the pedestrian wall ordinance. At the same time we did that, we recognized that might let loose an environment in the Fremont Street experience that we meant to control with these ordinances the first time around. As Mr. Victor just stated, the Fremont Street experience funds itself through the sale of advertising, through the sales of carts, through other commercial advertising in the mall, and they control that entire environment. And the payoff for the taxpayer is that the operation and maintenance is solely upon the shoulders of the Fremont Street experience. Taxpayers haven't paid for 1 kilowatt of electricity, or the replacement of 1 light bulb, or the cleanup of 1 stick of gum on the ground. Our concern was that without something to replace those ordinances as soon as possible, that environment might suddenly become out of control and might turn into a situation where, as Mr. Victor noted, who would pay for a push cart if you can set one up for free? Who would stand for a light show or for a concert if you're going to be solicited on the spot and scared out of the mall or driven from the mall? So we put these ordinances together, and I asked that they be fast-tracked so that they be eligible for adoption in as short a time frame as possible. What that meant was some risk. It meant that we had to publish earlier than we would normally publish so they'd be eligible at the soonest possible date, which is tomorrow. As a result of that decision, if they're not adopted tomorrow, they die, and we have to start the whole process over, and we'll end up in a position where the soonest you could probably consider these would be the middle of December, maybe the end of December. And that's just the reality of the situation. I will state on the record, not that I expect it's going to ally any concern of union members at this point in time, that the original ordinance regulating mall activity under 11.68 recognized that there are certain protections that unions have that exist under federal law above and beyond that which the Constitution gives. The National Labor Relations Act, passed by Congress many years ago, affords union members the right to do things on private property that the average citizen couldn't do. In other words, gives you more protection than the Constitution. You can go into break rooms and give people brochures to solicit membership in a union. You can stand outside the doorways of private property to get people to become a member of the union. And you can protest as well on those properties as rights given above and beyond those that are in the Constitution. I can state that we are very much aware of those rights and how they've been defined in the case law, and nothing in these ordinances is meant to in any way chip away at those additional rights that unions have under the National Labor Relations Act. So your rights to organize and to protest and to do other things that are protected well above and beyond the Constitution are still intact and, in my opinion, not impacted by either of these ordinances. I'll put that on the record if that's some consolation. I will also offer the Carpenters Union and any other union member this as well. If there are concerns that I have not addressed or we have not addressed in a short period of time, we'll be happy to meet with anybody, and if a problem can be identified, we'll be glad to put these back on the agenda. But I think, given the fact that I don't think that there's a risk to anybody conducting union activity in the mall as a result of these ordinances. And I think there is a tremendous risk that the mall may become a very unregulated environment in very short order if we don't put something on the books fairly soon. I would still recommend it to pass on this ordinance at this time.
Did you have any more comments?
I just had one question just to clarify. If there was a labor dispute at a property, I don't want to mention anybody by name, but just say there was a problem. You mentioned organizing within the property. If we were to have a picket line on Fremont Street outside the walls of the property, would this ordinance affect that in any way?
In our opinion, you could have done that under the old set of ordinances that were ruled on by the Ninth Circuit. We never tried to regulate that activity. And so you could have picketed under the old ordinances, you could picket under the new ordinances.
Okay. Oh, thank you for clarifying that.
Is that to take care of your questions then?
Yes, thank you.
Thank you very much. Is there anybody else who wishes to speak?
If I could, before Lee Rowland speaks, we've been making kind of a mixed record here on item number 7 and item number 8. Could I ask, with the recommending committee's permission, that you read item number 8 into the record this time as well, and that way we can discuss them both and have the same record that pertains to both items?
I think that's a good idea since it's closely related.
So reading item number 8, Bill number 2006-64 adopts a new chapter 11.68A of the Municipal Code relating to the city's pedestrian mall, proposed by Brad Jervik, City Attorney. And we're doing these two together in comments made because of the close association of the two items.
Thank you. I think that's very sensible and efficient. My name is Lee Rowland. I'm the staff attorney of the ACLU of Nevada, again for the record. I'm glad that Mr. Jervik explained the expedited schedule because that was certainly one of our concerns here too. So with that in mind, obviously this is, we have a long history between the city and the ACLU on this issue. So I hope that I can say this frankly and honestly, which is that we're here because we believe it's still unconstitutional. We have an excellent track record. That's not by means of bragging. It's simply to say that this is meaningful for us. I mean, if we really intended to go out and litigate, we would do it. We don't see any value in that. We live here too. We would really prefer to have a conversation about the ordinance and express our concerns. And because of the timeline, that's obviously not possible here. So I think based on Mr. Jervik's explanation, which is certainly reasonable, nonetheless, we would say that I would think it would be better to have, I mean, I don't think it will be anarchy, but to have a month of possible anarchy at the worst in order to create an ordinance that doesn't have the constitutional flaws that we believe this one still has. I'm glad we did consolidate 7 and 8 because 7 includes the definition of solicitation, which adds the word immediately. It certainly does change things a bit. However, the Ninth Circuit has been clear that in a public forum, which Fremont Street has been designated by the Ninth Circuit, that when sales are included with protected expressive activity, such as a nonprofit group selling T-shirts or accepting donations, that is fully protected in a public forum. The name of that case is Gaudia Vaishnaya. I'm sorry that it is not in my memo. So even though the word immediately may change somewhat the way the court looks at this, it's pretty clear under Ninth Circuit precedent that the activities that are now expressly prohibited under Section 8, we don't think they're going to be any more constitutional because the Ninth Circuit case law makes pretty clear that that's a dead end. So again, what we're looking at is the same 3 exact stipulations that were struck down by the Ninth Circuit with the addition of the word immediately. From our view of the case law, that really doesn't change the analysis here because the court has already looked into that in San Francisco and said if people are selling and it's expressive, they have the right to do that in a public forum. Now, I fully respect if people in the council don't like that opinion, but nonetheless, it is the law in this circuit. It is how the Ninth Circuit has decided the constitutionality of other issues. Those were on the wharves of San Francisco, which, if anybody has been there, is a semi-privatized environment that is intended as a tourist destination. There was no indication that after having ruled that that Fremont Street is a public forum, that it would be any different in this situation. Secondly, the specific section of the new ordinance 64 at section I apologize, I believe it's 100K. Oh, that's new solicitation, fine. The sections B and H are virtually, I believe, completely unchanged, except for that in H it says for purposes of solicitation. I'm assuming, to give the benefit of the doubt, that that now includes the new definition as under K. But even with that, as I said, they still have the problems. And I just want to note that the addition of a paragraph in the law that says, none of this is intended to abrogate the derogation of the constitutional and statutory rights of any person, that's inadequate in federal law. The federal courts look at what the plain meaning of a statute is, and right now, reading this statute, what's clear is that solicitation is banned, setting up the table to solicit is banned, and while that may be a laudable goal, it is clearly exactly the activity that the Ninth Circuit just said you cannot prohibit in its recent case. So I'm mindful of the changes that have been made. I certainly don't mean that any of this has been done in bad faith, but nonetheless, we think this ordinance is still so close to the other ordinance that it's literally kind of playing games with the court. And to some degree, I think the Ninth Circuit decision deserves a little bit more reverence. And as I said, we're here in the spirit of collegiality. We would love to give our input. And if that seems self-aggrandizing, I apologize. It's clearly because we believe that we have a great track record on the First Amendment, and we would prefer to be having a conversation rather than doing an expensive litigation yet again on this ordinance, which I can assure you, if it passes in this current form and someone is cited under it, we would certainly consider. And that's not a threat at all. It's simply the truth. We still have the same concerns, and I'd be lying if we said otherwise. So in the hopes of sparing some taxpayer dollars on an unnecessary lawsuit, we request the opportunity to work with the city attorney's office. We're certainly willing to be reasonable and see if there might be a middle ground that we could agree on that might both prevent a lawsuit and ensure that Fremont Street is not the anarchy that you fear. And while I understand the time press, I fear in this case it may be a penny wise and a pound foolish, because you may have 1 month covered, but it certainly might mean another 8-year litigation battle, which I really don't think is in anyone's best interest. So, and again, I really mean those comments as positively as I can. We would love the opportunity to, speak about it before we end up in a legal battle. So that's certainly why I'm here. We, just like the Carpenters Union and other unions that have contacted us, would really love the opportunity to have more time to see if this can be worked out. And see if a version can come through that we can live with, that the city can live with. I think that would be in everyone's best interest. And if the city isn't willing to do that, we certainly understand, and thanks for the opportunity.
I thank you for your words of collegiality, and I understand your strong commitment. And of course, there is a strong commitment on keeping what we have in the Fremont Street experience as it is now. I believe that the councilman wanted to make some comments.
Thank you, Councilwoman. Thank you very much for your presentation, as well as the Carpenters and the Fremont Street experience. In our role in this position, and let me back up, in your respective roles and your positions with the ACLU, the Carpenters, Fremont Street experience, this is what you're supposed to do here if you see something challenging coming up. The councilwoman and I, and the council in general, needs to look at the big picture. The economic viability and sustainability of the Fremont Street experience is a priority of ours, without a doubt. Jobs are on the line, without a doubt. Protecting workers' rights to picket or to increase their members by organizing efforts, absolutely important as well. This is a fairly union town. At the same time, protecting the civil rights of individuals. So we need to look and examine the big picture. I think in regards to Mr. Jervic's explanation of the time-sensitive issue of trying to get this through quickly, I understand that, and I absolutely accept that because of the priority of keeping the Fremont Street experience economically viable. But I've got to share personal experience with you. I've been solicited on Fremont Street. These laws that we create don't always have great effect. So if someone's going to solicit you and ask you for a buck or ask you for a beer, they're going to solicit you, regardless if it's legal or not. But I understand where the ACLU is coming from, as well as the labor organizations. I'm very in tune with the labor organizations, and I haven't been contacted on this, which is surprising. If the AFL-CIO felt that this was an issue, I'm sure my office would have been contacted, and I may have a message upstairs, I'm not sure. But this is a priority of mine also. Councilman, as we review this and think about this, I think it's in the best interest, and I will get legal counsel on this. If we pursue this, Mr. Jervik, can this not be amended? Can we not, our legal teams, enter into conversation with the ACLU in regards to their concerns and the adjustments of? Is this not a living document or a living law that, gosh darn it, this is what we got on the books now? We need to bring this back at the end of December to see if we can adjust this.
Absolutely. To anticipate your question, I would, first of all, extend to Lee and to members of the ACLU, if somebody wants to come to us at any point in time and look through this document and say, we recommend this change or this change, we may not agree at the end of the day, but we'll always have that dialogue.
And that's okay.
That's okay. We may agree at the end of the day. One thing I can also point out, though, is that as big a body as the ACLU is, and as nationally visible as they are when it comes to constitutional issues, in particular First Amendment issues, I do have to point out the ACLU does not speak for every citizen in this country. They speak for the ACLU. You could reach, technically, agreement with the ACLU on language that protects the law and does not step on the constitutional rights that they think are affected here, and which, by the way, we disagree, but I need to put that on the record. You could have that kind of agreement and still have a citizen out there say, you don't speak for me, I don't like your ordinance. So I don't know if there's any particular way that you get bulletproof when you do an ordinance that does a time, place, and manner restriction when it comes to First Amendment conduct.
And Councilman, if I may, I think that's the great thing about the democratic process. Not everybody's going to be happy. But as long as we're sitting down at the table talking about it, as long as we're protecting the rights of workers, as long as we're protecting the rights of the individuals, and as long as we're protecting the rights of the businesses that we want to see be successful, especially in the downtown corridor, we're heading in the right direction. I don't think by moving forward with this, it's going to affect labor issues, because I'm going to be the first one to holler and scream about that. And I'm sure you can work closely with the ACLU in regards to other issues when it comes to the constitutional law. That's your department, that certainly isn't ours. But we need to be proactive, think outside the box, and think about the big picture here.
And I think as the things we discussed today pertain to the union issues, and from what I was able to find out, it would not affect you adversely. And if you have any questions on that, or anybody in your organizations, I'm sure you could come to Mr. Jervik. But from what we've been able to ascertain, it would not affect you adversely. I think both of us would feel very strongly about that.
Absolutely.
And the other thing is that, there is a balance there with ACLU and with others and how they feel. And these are things we need to work out and perhaps be able to have a win-win balance if at all possible. Now, I realize that it may end up where you would need to take us to court again. And your record is admirable in that. You have done well in taking us to court in that particular area. But this is not taxpayers' money, as I've been told. This is money that's coming from the Fremont experience that's paying for it. So it's not that we're saying, okay, let's just go on this chase and let the taxpayers, give up money for this. This is not the case. Every single penny of this, the expenses of ACLU, as well as the expenses that have occurred otherwise, have been covered by the Fremont experience. So I did want to mention that.
If I could clarify in the record, too, Mr. Henry, who's our senior litigation counsel, who is present in his litigation team, we are salaried employees of the city who will get the same salary whether we're in court 24 hours a day or we're in our offices 24 hours a day. So to the extent that the city is paying for our salaries, that is an expense the city is absorbing, but you're paying that anyway. With respect to everything else you said, that's exactly correct, Councilwoman. The cost of outside lawyers have been 100% borne by the Fremont Street Experience, and any costs associated with the ACLU's winning have also been borne by the Fremont Street Experience. I expect that will continue to be the relationship.
Any other comments from the audience?
I just have a couple of technical things I need to say for the record. First of all, with respect to item number 8, that's bill number 2006-64, tomorrow I intend to submit a first amendment to that bill. It's just a very small technical change, but I noticed it today. 11.68A.010 is kind of the predicate for why we passed, why the council passed the original ordinances in the 1990s. And it says, council finds that there has been a progressive decline in economic growth and vitality of businesses located in the central business district. And it goes ought to speak in the present tense. I intend to submit new language tomorrow that will say, when this ordinance was originally considered in whatever year it was considered, the council found that there was a progressive decline. So I want to put it more in a temporal context. The second paragraph says the City Council further finds that it's in the public interest to select and contract with a private operating entity. Language will say something to the effect of the council found in 19 whatever and continues to find today that is in our interest to contract with a private contracting entity. So those are changes that will be coming your way tomorrow, and they're very small. They don't affect materially any of the changes that we've submitted today for the ordinances. The second thing I'd like to do at this point in time is incorporate in the record all records made with respect to 11.68 and M.44 that have been made either at the recommending committee or the city council meetings over the past several years since these ordinances were first introduced. We made a number of findings with respect to solicitation within near doorways, solicitation that's coercive, solicitation that is at a public transportation facility. And the underlying facts that this council relied upon in passing those ordinances back then need to be incorporated in the record today so that when we eventually, if there's litigation, that record exists for these ordinances as well. So any record with respect to 11.68 and 10.44 should also be incorporated into this record. With that, I don't have any more comments. Sitting next to me, I need to point out, is Pat Riley with Hale Lane, who is also counsel for the Fremont Street Experience and has been involved in litigation. I don't know if Pat had anything to add for the record, but I wanted to introduce him and give him that opportunity.
Nothing at this point other than to say that with regard to the new ordinances that have been presented before you, the intent has been to comply with the Ninth Circuit decision and to create a very practical framework and yet still satisfy the concerns that the Ninth Circuit had. There's no bad faith here. There's no attempt to quash anybody's viewpoints or free speech rights, but simply to do what the Ninth Circuit has told us that we could do, and we believe that we've followed that roadmap here. Thank you.
You're welcome. Any other comments from the audience? From Councilman?
Yeah, Councilman, in regards to Mr. Jerbick's comments on agenda items 7 and 8, as I make the motion, Mr. Jerbick, let's include the as amended portions in this meeting, and you'll be prepared for, I believe, Mr. Steve, we can do that as amended and incorporate Mr. Jerbick's comments in agenda item number 7 in regards to the history of these laws. Is that correct?
Yes, and what you're saying is that you would, with respect to the item number 8, you would recommend that the First Amendment be presented tomorrow with the changes to the 2 paragraphs that he indicated.
Yes, that's what you know what I meant. Okay. With that, Councilwoman, I'm prepared to make a motion. On agenda item number 7, bill number 2006-63, I would refer to council with a due pass, including Mr. Jerbick's comments of the history of these laws that we're associated with.
All in favor?
Aye.
Aye.
And on agenda item
The
number
motion passes.
agenda item number 8, bill number 2006-64. I would also move to refer to council with a due pass with the First Amendment. Mr. Jerbick will present to council tomorrow. And as I make that motion, Councilwoman, it's important that as we discuss it here at the recommending committee, it's very important to get all of the council's input and their thoughts.
Right,
So
right.
all of the parties who are here today have an opportunity to be at the council meeting tomorrow and voice their concerns and do the same thing in a public forum. And that's my motion.
That's right, and also urge to discuss with Mr. Jerbick any suggestions they have.
And you'd like to incorporate the history of
Yes, and that
11.68 original in
Yes.
the record with this.
Yes, thank you for that. That's my motion, Councilman.
All in favor?
Aye.
Aye. Motion passes. Now the time for speakers from the audience. If anybody wishes to speak. If not, then the meeting... Oh, did you want to say anything? All right, the meeting is adjourned.